Hello, everyone. This is Adam Childers at the law firm of Crowe Dunlevy. We're here for a special event today. We are putting on a webinar that we are co-hosting with the OKHR State Council. And I am joined today by my colleagues. And this is unlike any seminar or webinar that we have done before, because we are, like I hope all of you are doing, we are doing our social distancing. So you will see to my right my co-chair of the firm's labor and employment section, that's Randall Snap. To my left is my law partner, Alan Hudson. And just below me and to my left is my law partner, Mary Snyder, waving to us from her studio there at her house. And then finally, our member of our group, Michael Bowling, here in the office. Give us a wave, Michael. There we are. So that is our team of labor and employment attorneys that will be here with me today. As I mentioned, we are doing this in conjunction with the OKHR State Council. I know all of us we're disappointed to see that the conference had to be canceled coming up in April. I say canceled, postponed, because it will be hopefully, and if everything turns out the way we hope and expect, it will be rescheduled and take place August 10th to the 13th, still in Tulsa, still at the Hard Rock. Crowe Dunlevy remains the premier sponsor for that event. We love to be involved with it, and we're sorry to see that it was delayed, but we're going to be there, and we hope that all of you will be there too. And what an incredible gesture by the OKHR folks to set this up, to provide this mechanism for us to reach out to our friends in the business community and human resources professionals in this time of need and spread some information that we hope is helpful to everyone out there. One thing I've learned, and I'm sure all of you have as well, is we're only going to get through this if we get through it together. So thank you, OKHR, for giving Crowe Dunlevy this opportunity to be a part of this outreach to the business community. For those of you who are clients of ours, thank you. For those of you who are friends of ours, thank you. And for those of you who don't know as much about our firm, just very briefly, we are the state's oldest law firm. We have offices in Oklahoma City, Tulsa, and Dallas. We are a full slate practice group law firm. We have all areas of practice, and of course our labor and employment practice is a very, very important part of what we do on a daily basis. We're all proud to be a part of that group. And we are working tirelessly. I can tell you the last couple of weeks have been nonstop working on helping employers put in place policies and procedures, travel restrictions, press releases, working on furloughs, reductions in force. If it touches on the issues of employment law and COVID-19, we have been on the scene. And it's an unfortunate time, but it's also a time for us to really be there for you. And so I encourage all of you, if you're not already talking to your employment law counsel, that you do so. These are hard times, but we can get through this together. Okay, so I need to make sure that everybody understands that what we're going to do today is no substitute for specific legal advice. This is an area of the law that is changing by the day. Some of the answers we're going to give today are not complete answers because we don't have all the information that we need yet. We will do our best to give you information that we think can help you in the workforce, but you need to talk to your employment counsel before you make specific decisions about your specific questions that you have. And obviously we're a resource for that, but I just want to encourage everyone to understand that that this is no substitute for specific legal advice. You know, speaking of OKHR as our partner in all this, you know, the theme for this year, the conference when it is held, is better, faster, stronger. And I think that's particularly appropriate for what we're all going through. This feels like a dark time, and it is. It's unprecedented. It's a once in a lifetime event for all of us. But I think we're going to come out of this on the other side better, faster, stronger. And the way we get there is arming ourselves with information and trying to make the right decisions in difficult times. So we kind of have the Brady Bunch here, right? We've got this. I'm a product of the 70s and the 80s as a child, so this is the closest I've ever come to looking like the opening sequence to the Brady Bunch. But what we're here to do today is this group that's been assembled is that we are going to talk about an overview of the Families First Coronavirus Response Act, the FFCRA. And we're going to try to go through that, and particularly the emergency paid leave provisions that are contained within that act. We are also going to look at other issues that are coming up when it comes to COVID-19, things like travel restrictions, self-quarantine, telework policies, the ADA, furloughs, layoffs, and we've also reserved time to talk about questions that have been submitted by you, our audience members, in advance of today's presentation. And we'll get through just as many of those as we can. We received literally dozens and dozens, if not hundreds of them in just a short window of time, just to give you an idea of the interest level and the questions that are out there. When we're done with this, we will be posting this to the firm's YouTube account, which a link will be sent out to get the word to everyone. And also, if you are not already on our firm's mailing list, we put out an advisory that summarized this law last week. I encourage you to go to crowedunlevy.com/subscribe. That's crowedunlevy.com/subscribe. This will also be going out on the OKHR mailing list, as well as affiliated human resource chapter mailing list. Thank you to the OKHR and the many HR societies out there that are making this possible. We want to get the word out to as many of you as possible. And again, if you want further information, be sure to subscribe to our mailing list. You have to opt in order to be a part of it, and then also look for future advisories on these on this information. So I'll be playing the role of moderator today, and what we would like to do first is jump in head first into the FFCRA. Had to think about that just for a moment. There's so many acronyms when it comes to employment law, but this is just another one for us to get a hold of. So just briefly, the FFCRA came about in pretty quick fashion, and obviously it needed to. About March 14th is when we first began getting word that the House of Representatives and Congress had put together the framework of it. There were some very serious questions raised by small business owners and other segments of the business community. Some technical changes were made as part of a package on March 16th. And then it was just within about a 48-hour window later signed into law after passage by the Senate and obviously being signed by President Trump. A lot is in this bill, and we're going to focus on the parts that employers and human resources professionals are interested in, and that's the paid leave provisions. But I encourage all of you not to take this as a summary of everything that's in the act. And I think you'll hear this in some of the answers you hear today. We are still waiting for regulations to be promulgated by the Secretary of Labor, and we think we'll get a lot of clarity. We certainly hope we'll get that clarity as we move forward, but that's a short way of saying stay tuned. Some of this is subject to change. But with that said, let's turn to the act itself and start giving an overview for our audience members of what it entails. And I'm going to first turn to Michael Bowling. Michael, can you talk first about who this act applies to? A lot of people are wondering, am I covered? So let's start right there as a building block. Who does this apply to?
So the Act applies to two types of employers, private employers with fewer than 500 employees, as well as public agencies, government employers, as defined by the Fair Labor Standards Act. From the perspective of whether an employer has 500 employees, both full-time and part-time workers, so anyone on the payroll, just as you do account under the Family Medical Leave Act, all employees that are current employees would count toward that 500 number.
All right, and so now we're talking about anybody that has at least one employee up to 500 employees. Is that a fair description then?
Yes.
Okay, and then for those employers, what, at least on the emergency FMLA leave, we're going to talk about a couple types of leave, but let's focus on the emergency FMLA leave. What is it that will be provided as a benefit for employees of covered employers?
Yeah, so the Act provides for an additional FMLA reason, public health emergency leave. That emergency leave is related to the need for a parent to stay home with a child whose school or daycare, that's public or private school, that's primary or secondary school, and any daycare that's closed due to reasons related to the pandemic, that they're able to stay home with their children to provide care for up to 12 weeks.
All right, and so for up to 12 weeks, are there any special provisions as it relates to the early days of those 12 weeks?
Yes, so with respect to the emergency FMLA itself, it provides that the first 2 weeks of the emergency FMLA would be unpaid, and then for the remaining 10 weeks that an individual can receive 10 weeks of paid leave, calculated at 2/3 of the regular rate, up to $200 per day.
And what's, you mentioned this earlier, but we're used to thinking about the FMLA as it relates to serious health conditions or adoption or placement of a child. What is the qualifying event? You referenced it, but let's make sure everyone understands what that qualifying event for that emergency FMLA leave is.
Yeah, so the qualifying event is that the employee is unable to work or telework, and that's important. If the employer allows someone to telework from home, then they do not need to offer this to that individual. But it's if the person is unable to work or telework because they need to stay home to care for a child who cannot attend their school or their daycare due to the COVID-19 pandemic, that's the qualifying reason.
Okay. So a fairly limited circumstance, at least for the emergency FMLA leave. We'll talk about a more expansive type of paid leave when it comes to emergency sick leave in a moment. But I think it's important to point out at this point that, at least according to news reports we've seen in the last 24 hours, State School Superintendent Joy Hoffmeister, it's anticipated that there may be a decision forthcoming in the next 24 hours on whether or not Oklahoma schools are closed for the remainder of this year, which obviously makes this very important for our Oklahoma employers when they're looking at whether or not this will apply. Let me ask you one follow-up question to this, Michael. What about the summer months when it would have been anticipated they would not have been in school anyway? Are we really only talking about an emergency FMLA benefit that extends through what would have been the end of the school year, or are there circumstances where you see that could go beyond that date?
I think there are circumstances that could go beyond that date. You'd want to talk with your employees about what their child care plans were for the summer. Any child that's in a daycare-like program or a child care type program could continue to be a child that needs care at home in the summer months and that would qualify for this emergency FMLA.
So, Alan, we've become familiar with the framework for the FMLA as it relates to who is a qualified employee. We all get out our calculators and try to determine if they've worked 1,250 hours, have they been with us for a year of service. But talk to our audience about what the Families First Act does as it relates to a qualifying employee for purposes of this act.
Well, it certainly greatly narrows those length of service requirements. It's actually just 30 days.
So just 30 days. When you say 30 days, so if you've had anybody that you've hired and they've been with you for at least 30 days, they'll be covered?
That is correct.
Okay. So obviously much more expansive in scope than the FMLA in terms of the coverage for emergency paid leave. But let's talk about something else we've become familiar with as it relates to the FMLA, and that's documentation. There's a pretty standard protocol that we follow in terms of certification process, documentation that we require. Where are we at as it relates to emergency paid FMLA leave? What documentation can we require, should we require?
Right. And because this leave is not related to the employee's actual medical condition, there's not going to be a requirement for a medical certification that we're all used to under the FMLA. And it's not entirely clear to me what type of documentation you could actually request in this circumstance, because as previously mentioned, it's pretty well known that the state superintendent is contemplating has shut down schools and is contemplating shutting down schools for the remainder of the year. So it would have to be a unique sort of set of circumstances in which I think that you would press an employee to provide documentation that they needed to stay home to care for a child under the age of 18 based on a school closure.
Yeah, and we'll talk about the other categories for emergency sick leave and maybe the need for additional documentation. But I think you've hit on a very important point, which is right now, think about what the purpose of this act is, which is to give relief to workers, and think about whether or not you want to, be the person that, has that battle on a hill over something that, is going to make it look pretty rough on the employer.
And to Michael's point earlier, if for some reason the regularly scheduled end of the year for a public school has passed, and it's generally known that most daycare type places have opened, and you've got an employee that's continuing to try to seek shelter under this leave law, that may present a situation in which you could ask some questions and try to get a little bit more documentation. But again, my advice would be to tread lightly in those situations.
Agreed. Now, just to make sure that those who are tuning in and watching this on our YouTube channel understand how this works. I know Michael mentioned this just briefly, but walk us through again how the paid benefits, how are they paid out during this 12-week period of time?
So again, the first 10 days are unpaid. The remainder of the 12 weeks is paid at 2/3 the employee's regular rate of pay.
Okay.
And
Go ahead.
And there are caps. They are not entitled to any more than $200 per day and a $10,000 maximum.
All right. And is that, well, we'll save that question for in a moment. But Mary, let's turn to you for a second. We heard Alan talk about this rate of pay, which is all well and good if we know what their hours usually are and what they are usually paid. But what suggestion or what advice and counsel do we give in situations in which the hours are unpredictable?
Well, this was actually addressed in the House bill that was passed. And what they've said is that employers need to look back over the past 6 months and determine the average number of hours an employee worked during that previous 6 months to determine what the rate of pay is. And then, of course, you pay out at 2/3 of that rate. Okay.
So we still have that gap there, that first 10 days. A lot of questions that we've been receiving are focused on can you force the employee to use PTO during that period of time? What's your read on that, and what's your understanding of what the Act tells us that we can do?
Well, the Act says that an employee may elect to use their paid benefits from an employer, which leads me to believe that we cannot require that of employees, that they indeed can have the choice to use it or not use it.
and again, we'll talk about the emergency sick leave here in a minute, but is there any overlap between the two when it comes to those first 10 days? And if so, what is it and how will that impact whether or not we're really truly talking about an unpaid first 10 days?
Well, yeah, so when we talk about the Emergency Sick Leave Act, what you will all hear is that it has a much broader group of circumstances that qualify for that paid time off. And one of the qualifying reasons matches the reasons in the emergency family leave. And so really for almost everyone, maybe everyone, though that 10 days of emergency sick leave would almost always precede the family leave.
Yeah, and just to double down on that point, for our audience, I think what that means practically is because the closure of schools or daycares is one of the enumerated reasons for emergency sick leave, we think that the two will kind of always go hand in hand. Now, stay tuned and see. Obviously, that changes somewhat when school is out or was scheduled to be out. But for the foreseeable future, at least, it looks like there is that overlap that Mary was just talking about. Randall, let's turn to you for a moment and talk about the FMLA. One of the rules that we've become familiar with is the requirement of bringing somebody back to the position that they held prior to their FMLA leave. Does that apply for this new emergency paid leave? And are there any new rules under the Act that would change that rule up at all?
Well, it does apply with one exception. So the requirement to bring the employees back to the same or similar position after the expiration of the FMLA would still apply. There is an exception, however, for employers that have fewer than 25 employees. If the employee's position no longer exists because of the public health emergency, and even in that situation, the employer would have to work with the employee to try to assist them to get through that process. But they would not have to restore them to the same position if that position was no longer there because of the public health emergency, if the employer has less than 25 employees.
Yeah, and Randall mentioned this, that the statute, the Act goes into some detail on what those efforts have to be. So Randall, I'm sure you'd echo this, but maybe you can speak to this. If someone is in a position where they have 25 or less employees and they aren't going to restore them to that position, I'm guessing that they need to be talking to council about what those factors are that they need to, sort of check the box to make sure they've made those efforts before they would release that employee.
That is correct. And then we also hope that when the regulations do come out, that they will provide more specificity as to what that assistance would be. Yeah,
and great point. When are those regulations coming out? I'm going to ask you I don't know how. I was going to say the $25,000 question. It's worth a lot more than that. Tell us when you think we might see them.
Well, there was a press release from the Department of Labor last Friday, and it had a lot of generalities, but not a lot of specifics. But one of the things that it did say is they anticipate getting something out for more guidance by the end of this week. So our hope is that we have that information out by the end of this week. That's really important because the effective date of the statute, we believe to be April 2nd. The statute said that it was going to go into effect no later than 15 days from the date of its passage, and that would be April 2nd. There's been some commentary about whether or not is it effective immediately. All indications we have is that it's going to be not effective until April 2nd. There have been some questions about what happens if you provide benefits prior to that date. Can you still obtain the tax credits that are available? And the press release that came out last Friday seems to indicate that the tax credits are only going to be in effect for benefits that are giving after April 2nd. So we're looking at right now as April 2nd being the effective date. Hopefully the regulations will be out by the end of this week, and then we'll have answers to many of these questions that right now are up in the air.
Yeah, and I think that's an important point that you made about the tax credit. We're not going to discuss the tax credits in detail today because one, we're not going to pretend to be tax attorneys, and two, I think that what you said is critical. for those who are saying, let's put this in place immediately, I commend the effort and the thought process, but please understand you may not get that benefit if you start it sooner than what we believe to be the operative date. So I think Randall's point is well taken. I think that's the best guess any employment practitioners can give you right now in terms of the start date and what that impact will be. Okay, so that is an overview of emergency FMLA leave. Now let's turn to the next chapter of paid leave as it relates to the Families First Act. Michael, I'm going to turn to you again for an overview here, but talk to us about emergency sick leave and how this differs from that emergency FMLA leave.
Yeah, so the emergency paid sick leave included within the Act provides for 2 weeks of paid leave for 6 qualifying reasons. It applies to the same employers we talked about before. So government employers, as defined by the Fair Labor Standards Act, and then private employers, that's both for-profit and not-for-profit with 500 or fewer employees. So it's going to have the same qualifiers there from an employer perspective, but different reasons that lead people to be able to use this paid leave.
All right, and we'll talk about those reasons here in just a moment, but let's also focus on a real key distinction here, which is we talked about, Alan gave us the definition of a qualified employee for emergency FMLA leave. Is that same 30-day rule apply when it comes to emergency sick leave?
It does not. It's going to apply to all employees, no matter their length of tenure.
All right, and I want to hammer home on that point for our audience. Be careful about using one box to decide who gets the paid benefits and who does not, because this is a situation where somebody who's been with you, for less than 30 days would receive something that you would not ordinarily receive on the FMLA side. Okay, so what about the telework situation? Does that still apply, Alan? The rules that you have to be unable to work or telework?
It does. It does. If the employee is able to telework from home, they're not going to be entitled to this paid sick leave.
And I'm sure that our audience is if they haven't used telework in the past, are probably up to speed on what it is. But just give us an overview of what we're talking about when we're talking about telework, and what those opportunities will be for employers, in looking at this situation.
Yeah, and most employers maybe dealt with this in another context with respect to the ADA and making a reasonable accommodation. But telework is essentially just what it sounds like. You are working with your workers, your employees, to identify whether or not they can perform all of their job responsibilities or a majority of their job responsibilities from home via mobile devices and computer systems.
And I think this sometimes gets lost in the noise about talking about this law. I think there's this idea that, well, if you have one of these qualifying conditions, which we'll talk about in just a moment, well, that must mean that I get that paid benefit, without this focus on whether or not the analysis has been done, whether or not they could actually telework. There are jobs that you cannot telework, but there's a bunch that you can. So I'd urge our participants in today's webinar to take that into consideration. But let's segue then, Alan, into what those 6 qualifying conditions are. We heard from Michael earlier on emergency paid leave. It's really kind of a narrow qualifying condition, but it's broader, isn't it, when it comes to ESL?
It is. There are 6, as you mentioned. I'm more than happy to read them. In the interest of time, I may abbreviate the 6 instances. Essentially, the first 3, I think, go to impacts that COVID-19 have individually on the employee, whether they've been isolated or self-quarantined at the direction of a government official or a treating physician. And then the other 3 really go to instances in which the employee is caring for someone else that has been impacted by COVID-19, whether they've been tested and found to be positive for it, or school closure, those types of things. So there are two categories.
Yeah, and I think that's a good overview for those who want to see the specific enumerated categories. We do have that as part of a client advisory that is posted on our website. You can walk through each of those 6. Is this something, Alan, that employers ought to be thinking about putting together an interim policy, and after the regulations come out, a more detailed policy about these, the application of these rules?
Yes, and actually the Secretary of Labor is supposed to provide employers with the required notices to give to employees. However, we don't have them yet. We don't know what they look like. Presumably they'll be comprehensive and cover everything that needs to be covered. I think that, yeah, having those communications, those notifications to employees would be a best practice. And I'm sure a lot of employers have already done this, because I'm sure the HR's door is getting knocked down with these types of questions.
Yeah, absolutely. And just again, for purposes of our webinar, that, what we're talking about, it's going to be individuals who are subject to a government quarantine or isolation, individuals who've been advised to self-quarantine by a healthcare provider, individuals who are experiencing symptoms of COVID-19 and seeking medical diagnosis, individuals who are caring for others who are subject to a quarantine order or self-quarantine, situations where the employee is caring for children because the school closure or their caregiver is unavailable. That's that overlap that we talked about earlier. And then individuals who are experiencing substantially similar symptoms. I think you can see that these are pretty broad categories, and chances are if you don't already, you're going to have people in your workforce that fall into one of these 6 categories. So that this is where you're going to really have to put a lot of your immediate attention. Mary, with that in mind, what is the rate of pay? Is it different than it is for emergency family medical leave? And if so, what is that? What are those rates?
Well, there are 2 different rates of pay that may apply in regard to this emergency sick leave. The first 3 categories that you just read off, if an employee is absent because of those 3 categories, which really relate to that employee themselves, then they need to be paid at least federal and state minimum wage. And it can go up to 2/3 of their rate of pay, just like with the other, but up to a maximum of $511 a day, with a maximum total aggregate payment of $5,110. So that's when the employee is having their own cause of sickness or isolation. The other 3 categories that relate to caring for a family member, the pay really is the same in the end as under the FMLA, the emergency family leave. It's the 2/3 of their pay up to a maximum of $200 a day, but only for the 80 hours.
And my understanding is that those limits, those caps, kind of correspond to the tax credits. And I promised I wouldn't play tax attorney here, but I'll put you on the spot here, Mary, but because I honestly haven't heard for sure, and if we don't know, that's okay. But is that going to be a dollar for dollar tax credits, or is that still a question mark as to whether or not employers would see the full benefit of that on the backside?
My understanding is that the government's intent was for it to cover the full cost of leave, but you need to be careful that you're only giving what the employee is entitled to, because I would suspect that if you are more generous than what is required, you pay more than the 2/3, for example, that you might not get that difference. But again, maybe we should do another one of these with our tax folks.
Fair enough. How about the effective date, Mary? Any differences as between emergency sick leave and emergency FMLA leave in terms of a start date?
We don't believe so. So April 2nd seems to be the effective date for all of this, and anything you do in advance of that is unlikely to be allowed as part of a tax credit unless regulations come out saying differently.
Okay, so that gives us a nice overview at this point of emergency sick leave and emergency FMLA leave. Of course, the questions don't stop there. In fact, I think what we have found as a group, and I'm sure you, our audience members, have experienced, is there's a lot of unresolved questions and big question marks about some serious issues. And so I'd like to delve into some of those and see if our panel can address some of these pressing issues and give a little bit of clarity on these topics. So let's start with one that I mentioned during the House of Representatives process. There was a lot of concern voiced by the small business community. We're used to the FMLA not applying to employers who have less than 50 employees within a 75-mile radius. However, there's nothing I've heard in any of our overviews about that being applicable here. Mary, what's on the horizon and what relief, if any, is there for small businesses as it relates to these requirements we've been talking about?
Well, sitting here today, there is no relief for employers with less than 50 employees. However, the Act did allow the Department of Labor to issue regulations that may exempt small businesses defined as employers of less than 50 employees in the event that offering the leave would jeopardize the viability of the business as an ongoing concern. The two things to think about there is, number one, that's not currently defined. Hopefully it will be in the regulations. And this all assumes that the Department of Labor actually acts on that and puts a small business exception into place.
And Alan, building on that point, if we don't have the regulations yet, do we even know how an application for exemption will be filed, what you need to put in it, who you send it to, how long you have to get a response, and even what do you do in the meantime if you don't have the capacity or resources to make those payments? I just threw about 5 questions at once at you, but what are your thoughts on that?
Well, I think the easy lawyer answer is we don't know what that application is going to look like, but presumably the Secretary of Labor is going to give us some factors that can be considered and that the DOL will consider in determining if you meet this exemption. I think in the meantime, every employer should be doing this that is going to be subject to these new paid leave laws and analyzing their workforce and analyzing the financial impact that these laws come April 2nd are going to have on their business. And because I think a lot of this analysis is what you're going to have to put in this application to receive the exemption from the laws.
Yeah, and I think it's a great point. If you, as a small business, are anticipating that you may be, someone who's going to have to file for this exemption, the time is now to start building that case, working with employment counsel, and having it ready to go, because I don't think you want to be making those decisions or going through that process after April 2nd. I think you need to start building that case and working with counsel now. That raises another exemption issue that there's been a lot of discussion about, which is healthcare providers. There's been some confusion as to who we're exactly talking about, but help us out, Alan. What do we know about healthcare providers and how will this work for them?
Okay, so both of the laws mention healthcare providers in 2 separate portions, and it's almost a redundancy. And so I think how healthcare providers, and really I should step back. I think the confusion is that folks read the regulation or they read a client advisory that has been sent out and they think, well, I'm a hospital. That means I'm a healthcare provider. That means I can be exempt coverage under this act. And that's not how it actually reads. How it reads is that an employer who has employees that are healthcare providers or emergency responders may exclude those individuals from coverage under these leave laws. And so the analysis is really not on an employer-wide basis, like what type of business am I in? It's on a employee by employee basis. What type of job responsibilities are these individuals actually performing? So a hospital is a great example. A nurse practitioner or a doctor is clearly a healthcare provider. However, somebody that's in administration, processing payroll, human resources, a comptroller, those folks are not providing health care to patients and therefore would not be excluded from coverage under the Act. The other real problem here is there isn't, unless the regs provide one, there isn't a definition for healthcare provider. And if you are required to rely on previous FMLA definitions with respect to who can execute a medical certification, the definition of a healthcare provider is pretty limited. It actually, covers your doctors, your nurse practitioners, dentists, podiatrists, clinical psychologists, optometrists, chiropractors in some situations, but it wouldn't extend to a nurse. And so that could create some problems, because I think the intent and spirit of this exemption from coverage was to allow hospitals to exclude their nurses and other, kind of boots on the ground healthcare providers from this coverage, because they need them in the hospital treating patients. And so I'm hopeful that we're not stuck with the definition that's been previously given under FMLA regs with respect to healthcare provider, because it will really limit the scope of who is and isn't excluded under these two new laws.
Yeah, and I can't emphasize this enough. We represent large hospitals, rural hospitals, regional hospitals, and I think the messaging from a lot of different sources has been, if you're a healthcare provider, you're a hospital, don't worry about this, it doesn't apply to you. And I think the message is that's not settled, and if anything, we read that differently, and you really need to be talking to your employment counsel if the plan is to just treat it as not applicable to you. Now, some hospitals have more than 500 employees, and we're going to see an exemption or not being applicable on that basis, but don't make it as sweeping as it's being described in some outlets. Randall, whether we like it or not, there will be litigation that will come about when some of the dust settles on this. Did the Act speak to any protection as it relates to small businesses, to the extent that they get any of this wrong for purposes of civil liability?
It did. The Act does have an exemption for employers that have less than 50 employees, that they would not be subject to civil lawsuits that are brought by employees. It doesn't impact employers that are over 50 employees, and even employers under 50 employees shouldn't feel like this is a get out of jail free card, because they still could have liability from administrative agencies or other federal or governmental agencies if they violate the Act.
Absolutely. Michael, what are your thoughts on immediate things that can be done? Are you seeing changes being made to existing policies, and also what's happening with those big banks of PTO, vacation, and sick leave that employees have? How are those being dealt with?
Yeah, so the law does not address how employers should proceed with their existing policies, so we can continue to proceed under our normal course of business in that respect. With regard to the accrual and payout of leave, Oklahoma state law provides that an employer is bound by its written policy, but has the opportunity to change that. So if an employer is looking at these emergency paid leaves and feels that they don't align well from a business perspective, from a cost perspective with what they were already providing, employers can choose to amend on a go-forward basis their paid leave practices to align them better with what their obligations are going to be under either emergency FMLA or emergency paid sick leave. So that's a go-forward. So if somebody's already accrued, though, that's an accrual, and the employer is still subject to pay out of that accrual. We're allowing employees to use it With respect to big banks of leave, employers cannot just simply take away the leave. So if somebody's accrued it, it is there to use. And as we talked about before, employees have the choice of whether to allow employees to use that if they're using emergency FMLA during the unpaid time or not. So there is some choice there from employees. Employers can consider how they pay out at termination. And so they do need to follow their policies, but to the extent they want to change their policy on payout at termination, they can change their policy, give notice to employees, and do something different going forward. But it does require a policy change, and employers do need to follow their policies until they make those changes.
Mary, I'll turn to you for another question that has been raised quite a bit. And I should say, I've seen you cough a few times over there. I know you're at home. Just for our audience, Mary is in self-quarantine. She is not symptomatic, I think, but we're like all of us, we're exercising abundance of caution, but just so no one worries out there about Mary or any of us. But Mary, let me ask you this. A lot of people are asking, what's the tabulation? What's the math? How do we get to the 500 employees?
Well, it's pretty clear under the emergency family leave provisions. They have inserted the 500 employee count into existing regulations. And so that is all U.S. employees, part-time or not, or full-time, anyone who is on the payroll is going to count. Now, it's a little less clear under the actual sick leave provisions. It's not clear yet whether they're going to apply the exact same count or whether there's going to be some different sort of count. Right now, the definition of employer there really talks to the FLSA, and the FLSA doesn't have a way of counting number of employees. So we're not entirely clear whether those are going to be consistent or not. But for now, it does seem that at least for the emergency family leave, that you're counting all U.S. employees.
Very good. Okay, so what we want to do now in the remaining time that we have is hit some of the specific questions submitted by our audience in advance of today's webinar. I think I mentioned it earlier, no way that we could get through all of these or even really more than a thumbnail sketch. We will continue to look at opportunities for potential future webinars. We may even have a cleanup section where we hit some of these and maybe others. Really depends on how things develop. And obviously there may be other things that we need to update on, particularly the regulations. But in the time that we have left, let's hit a few of these questions. I think they're incredibly insightful and really show that all of you are dealing with these issues at a level that shows that, you know, a sincere care for employees, but also how do we make this work for the employer. So let's turn to the first question, and Alan, I'll pose this one to you. The question is, will employees under a stay-at-home or shelter-in-place order, similar to what we've seen happen in California and now other states, will they be eligible for emergency paid sick leave under the Families First Act?
I would say yes, and I would point to specifically the one of the first categories in which you're available for that paid sick leave, which I refused to read earlier. The employee is subject to government quarantine or isolation order related to COVID-19. I think, as written, and that's relatively broad, I think that the courts and the OL would probably land on the side that yes, that would be a qualifying event that would allow the employee to take that paid sick leave.
So Michael, I want to build on that answer because I see another question that has a little bit of a nuance to it as it relates to Alan's response. This question is, will employees who are unable to work because their business has been closed by mandate, for example, restaurants or bars, as we've seen Oklahoma City and Norman and other municipalities do, will they be eligible for emergency paid sick leave under the Families First Act?
That's a good question, Adam. We hope we get some regulatory guidance in that respect. Right now, I would say that the safe answer is that an employer who's maintaining employees on its payroll should consider the reasons beyond the inability to work, and whether so if somebody let's say somebody works in a restaurant, they can't go to work, but then they develop symptoms of COVID-19, or they have to care for a child, any of the enumerated reasons for emergency FMLA or emergency paid sick leave, I think the safe answer would be to go ahead and extend that benefit, even if they're unable to work anyway due to the restaurant closure. I do think it's an open question that people are certainly wrestling with. What ultimately led you to be away from work? Was it the business closing and I sent you home, or was it your particular enumerated reason? So it's possible that we'll get better guidance from the regulations. I would say today, though, the safe answer is if you've maintained people as active on your payroll, you should consider whether they have one of the qualifying reasons and thus would be entitled to one of the paid leaves.
Randall, this next question goes to the issue of exhausting FMLA benefits. The question reads, will individuals who have already used and or exhausted their FMLA leave be able to utilize the emergency FMLA? What are your thoughts on that?
We think that this is just basically another category of qualifying event for FMLA. So we think that the 12-week limit would apply to all FMLA leave, including this. So if you've already used up, say, 10 weeks of your FMLA for another reason, you would only have 2 weeks left of that FMLA leave. If you haven't used up any, you would have the 12 weeks subject to the initial period. So unless the regulations tell us otherwise, we think that this is basically going to be read in conjunction with the existing FMLA.
Yeah, and to build on that, I think it's absolutely critical that you keep track of the regulations, because when word gets out that somebody's back from maternity leave and has used up all or most of their FMLA leave and now can't use its emergency leave, I think you're going to see some tremendous public backlash, and wouldn't be surprised if they don't lean into that punch and address it. But Randall's point, I think, is exactly the right reading of what we see right now, absent some further guidance from the regulations. Michael, let me turn back to you on an issue of the employee count. The question reads, I understand the act is for private employers with less than 500 employees. However, we are a multi-work site company, and combined, we are well above the 500 employees. Just want to confirm this is for total employees versus by establishment. So for our companies and clients and good friends in the business community who have these kinds of setups, what is your response?
Yeah, so for a company that operates just as a single enterprise, but with multiple work sites or establishments, that's an easy answer. It's going to be the total number of employees for the establishment. With respect to our clients who actually operate multiple companies, generally employers try to avoid being an integrated enterprise for lots of reasons. But this is an opportunity where an employer may say, hey, we are in fact an integrated enterprise. And that's a very fact-specific analysis. But companies that share management, share finances, but hold themselves out to the public as different companies, sometimes they're integrated enterprises, and their combined employee count might take them over the number. I can't give specific guidance there because it is dependent on the company, but this is an opportunity where certain companies may in fact cross 500 employees if in fact they're truly integrated.
Michael, while I've got you in this line of thought, let me ask you, we see a lot of employers that are turning to furloughs as an opportunity to try to hold on to the workforce. We have a question about whether or not if there's a furlough of their employees for a few days a week, will that make those employees eligible for partial unemployment? Thoughts on that?
Yeah, so the definition of unemployment under Oklahoma state law hasn't changed. So in order for somebody to be unemployed under the Employment Security Act here in Oklahoma, they have to work less than full-time hours, which is defined by the OESC as less than 32 hours a week. So if you furlough people to below 32 hours a week on a partial schedule, you're going to meet that criterion. In addition, the person has to earn less than the base rate plus $100. So their weekly earnings have to be less than $639. Our current base rate is $539 a week, and then the statute adds 100. So if you furlough people to a partial schedule, they work less than 32 hours and they make less than $639 per week, then they're eligible to apply for unemployment benefits.
And Mary, I know that you help us with a lot of wage and hour issues. Are there any special wage and hour laws that we need to be aware of for those employees who only work enough hours to cover their health benefits during this pandemic?
Yeah, I am encouraging employers to be a little bit careful with that. If employers are sending employees home for the employer's own purposes, right? We want to have people work at home because not because you're ordered to by a governmental agency, but because you are making that decision. You need to be careful with your exempt employees. When an exempt employee works any hours in a week, they are entitled to their full salary unless they are absent for their own personal reasons. And so while this plan may be fine for your hourly non-exempt folk, you need to do a different analysis if you're trying to apply it also to exempt employees.
Alan, I know that you have helped a lot of our clients with OSHA-related issues. I'm going to kind of aggregate a few different OSHA questions that we got and just ask you in general what impact this act has on general OSHA rules, and what advice do you have for clients that want to comply with that?
Well, obviously OSHA is primarily responsible for workplace safety. So this is obviously something they're paying close attention to, and OSHA has actually issued a guidance on preparing workplaces for COVID-19. And what's interesting within that guidance, and you can go to the OSHA website, it'll be on the front page, and I would encourage anybody that has really specific questions to print that off. But it's interesting, OSHA basically admits we don't really have any standards that are specific to COVID-19. And they generally talk about PPE standards that may be applicable, the general duty clause, and then any bloodborne pathogen standards that may be applicable. And really, I think where you land on this is the general duty clause. And if you've got an employee that you believe to have been infected with COVID-19 or have been exposed to COVID-19, you have a responsibility to protect the other coworkers from also being infected. And so I think OSHA is really trying to get the message out there that you need to analyze your workplace to determine what level of risk you're at. And they've got various levels. They've got very high risk, medium risk, and low risk. And based on that analysis, you need to be implementing engineering and administrative controls to try to prevent the spread of COVID-19 within your workplace. And then just lastly, if for some reason you think that somebody's been infected with COVID-19 in a work-related manner, always remember that you may have some reporting and recording requirements with respect to that workplace illness.
Randall, let me turn to you for a moment. I thought this question is one that we're going to probably see from a lot of different sectors. Is there an age limit for your children that you need to care for? This goes to the issue of both emergency family medical leave and emergency sick leave. This individual who submitted this question says, what about an employee with a 15-year-old that is out of school that the employee says they need to care for? Is that treated differently than a toddler or someone who perhaps needs more day-to-day care? How's that going to be handled?
So we anticipate that the regulations when they come out are going to be consistent as much as possible with the existing FMLA, which speaks to caring for son, daughter, children. So we anticipate it's going to be the same thing. A 15-year-old undoubtedly would still be covered because they're out of school, high school. The question is at what point do you not need to care for your children? And we'll see what they do with that regulation. I would posit that, once they get off to college, you're not caring for them much anyway. But a 15-year-old would certainly, I would believe, would be covered, and existing regulations would probably would cover that. So I think it would also cover under this act.
That also raises an issue of the Americans with Disabilities Act and kind of the intersection that we're going to see here with individuals who want to take off work because they might have an underlying complicating medical factor versus those that are worried about being in the workplace. Michael, I was wondering, can you speak to that as you know, human resources professionals are going to be having to make hard decisions? Talk about accommodation versus, you know, fears, whether justified in fact or just perceived.
Yeah, so based on the guidance from the CDC and everything we're learning about COVID-19, there are certain groups that are more susceptible to serious illness and infection from it. So employers are going to have workers who, due to underlying health conditions, are more likely to have a serious complication. And that's going to not only bring up questions about leave under what we've talked about, but also whether allowing people to either work from home or to be absent from work beyond these protected leaves, if one of the reasons qualified is a reasonable accommodation under the Americans with Disabilities Act. It's going to be the typical ADA analysis in terms of whether the employer can accommodate that, whether it's reasonable to do so, whether there's an undue hardship. One kind of thing I would have employers watch out for is they may have employees who have not needed an accommodation to date. You know, they've been able to work just fine, but have still had this underlying health condition. Those employees may today have trouble getting appropriate documentation. People's access to healthcare providers for kind of routine matters is limited these days. And so employers are going to want to be careful about the level of documentation they're requiring today from employees who just may not be able to get that documentation. So they're going to have to tread lightly with their documentation requirements. You mentioned people who are just concerned. Fear is normal during this. But fear also is not a disability under the Americans with Disabilities Act. And so employers are going to want to be thoughtful both to address those things fairly. I mean, people's concerns about being at work can go to their OSHA issues under the general duty, as Alan talked about. So they want to be thoughtful about the concerns employees are expressing. But in the end, if an employee does not have one of the qualifying reasons we've talked about, or an underlying issue that renders them disabled under the Americans with Disabilities Act, you could require them to come to work. You would want to be thoughtful as well about requirements under the National Labor Relations Act. People coming together to express concern about the workplace conditions related to COVID-19 is going to be probably concerted activity. And so to the extent you have someone who has been vocal about this, you want to be very thoughtful about any corrective action that you were taking as a result of them not wanting to come to work.
Yeah, and thanks for that thoughtful response. And I think it highlights that the ADA is going to be a particularly complicating factor as we go through this. One of those issues that I see come up quite a bit is something, Mary, that you addressed in a recent advisory, and that is this issue of taking employee temperatures before they enter the premises. I know this has been a quickly evolving topic. Tell us where it stands today.
Well, where it stands today is that the EEOC, maybe last week, maybe the week before, put out some guidance saying, okay, we're now at a time where, yes, you can take employees' temperatures. Yes, you can. I've had some clients wonder, how does one do this? You know, just from a practical standpoint, that's going to vary a lot from employer to employer. There's no one size fits all approach to that. Obviously, if you're using a forehead thermometer, you're going to want to be cleaning that between uses. I mean, there are a lot of different issues, but that really something that you're going to have to look at your workforce and kind of how your employee flow works to determine how to go about it.
Any thoughts on what happens if there is an objection to it on religious grounds, or whether it's just an act of insubordination? I mean, candidly, I've had clients tell me, some people say, not going to do it. And what do you do in those circumstances?
Well, I think that because the EEOC now says you can do this, that if an employee refuses just on general grounds, I don't want to, I think that you could view that as insubordination. I don't know that I would in this environment discipline the employee for that as much as tell them, okay, well then you can't come to work. But there might be situations where my answer to that would be different. Now, if somebody has a religious objection to it, I think you still have to go through an accommodations analysis. You might ultimately be able to get to the other side of that and say, no, this public health crisis is important enough that that trumps the religious objection, but I'm not sure about that, right? It would be very contingent on the context.
Yeah, Alan and I were having a discussion the other day that this may be one of those unique situations where we finally are talking about undue hardship in the accommodation process, whereas we usually are just talking about whether or not there is a reasonable accommodation that can be made, and we rarely kind of get to that last piece, and if so, we are able to establish it, but that may be different in this type of circumstance. Randall, I've got a practical question raised by one of our audience members. Will the Families First Act be retroactive for emergency FMLA or paid sick leave for those who have already had to stay home due to schools being closed? What say you to that?
All indications are that it will not be retroactive, that it will be in effect as of, it said up to 15 days, but we still think it's going to be April 2nd by the time they actually get it effective because of the need to do all the regulations. So unless there's something in the regulations that tell us otherwise, there should not be anything that would make it retroactive. Certainly you can again provide the benefits ahead of time. If you want to do that, you just need to be cautious that you probably won't get the tax credit if you do so.
So Mary, we've all grown accustomed to intermittent leave under the FMLA leave structure. Is intermittent leave spoken to in the Act, and if not, how do you see that playing out if there are requests for intermittent leave?
Well, it's not addressed in the Act. We sure hope it will be in the regulations, but reading the Act on its face, right now, without any guidance to the contrary, I would encourage employers to allow this leave to be used on an intermittent basis, because it makes sense that there may be days when, especially if it's for like childcare. I mean, if somebody's in self-isolation, they've got to stay there for 14 days, so that's not going to be intermittent. But if they're using it for childcare because their school's out, it may be that 3 days a week they have someone who can cover them, but 2 days a week they can't. And in that context, it makes sense to me that intermittent leave would be required.
I'm going to stay with you just for a moment, Mary, and combine a couple different strains of questions that we've received. A lot of talk about use of furloughs or reductions in force as a response to control costs and make hard decisions. Can you tell our audience what a furlough is versus reduction in force, and what the benefits to one of those approaches might be if employers are looking at those difficult choices?
Yeah, sure. So a furlough is a temporary layoff. So you need this person to come back on the backside. You know that you will still need that position. And typically you're going to give a set end date to that. Now, this is a developing situation, so I imagine that some employers will furlough employees, and if this situation continues, may have to extend that furlough date. But a furlough really is, we need this workforce, but we're going to lay you off temporarily. Under Oklahoma unemployment rules, a person can then get unemployment and they don't even have to look for another job if that end date is in place. So it helps you to retain that same workforce. A reduction in force is different because you're laying people off kind of on an ongoing basis. And this is really what employers need to use when they are downsizing, because they have no idea what their business needs are going to be on the backside, right? And so it's much more ongoing. I've had some clients even ask, is there a difference between a reduction in force and a layoff? I think that's a harder question. The client who asked me this said, well, the issue is that a reduction in force implies that I don't think I'll ever need these employees again. I've never heard there be a distinction between those two situations before, but maybe in this context there is a difference in those meanings. But yes, employers need to look at their own situation and what they believe is going to happen on the backside of this when they're deciding, is a furlough right for our business, or do we need to do something that's more long-term?
Yeah, and I think there is a difference emotionally when you hear layoff versus reduction in force. I think it also goes to whether or not you give them recall rights is something you hear more in a labor context. But if you tell them, look, if the business allows for it, we'll hire you back, versus reduction in force sounds a little bit more like this could be the beginning of the end for that job ever being replaced, or at least, not replaced for a very long time. So I think that's a really good point, Mary, that there are functional differences, but really some of this is just the psychology of what the employee hears when they're told this. Just final question that to round things out, and I'll pose this one to you, Alan. The question is, what does it look like if an employee has a sick family member and then that employee also gets sick as well? And this goes to this issue of sort of combination of FMLA time. What's your read on how that's handled under the Act?
Yeah, and initially, I think this question, when you were reading it, light bulb went off in my head that this person's talking about the 80 hours paid sick leave. If they need the paid sick leave to care for a family member, and then a month later they get sick, are they entitled to another 80 hours? And I think as the law is written, it speaks to 80 hours. It doesn't say 80 hours for each qualifying event. And so my answer, I think, would be in that situation that the employer is only required to give 80 total hours. And if there's a later qualifying event, it's not going to be required to give it an additional 80. The employer certainly can decide to do that. However, again, this whole tax credit business, I'm not sure that the federal government is going to refund employers for providing more than the law requires.
Well, we've gone past the hour that we allotted for this. I'm looking at the questions that have been submitted, and we didn't have the ability to get through, like I say, even a thumbnail sketch. We did try to do a good job of sort of consolidating questions into certain areas, and also a lot of these questions were answered in kind of the main summary that we provided of the Act. But the real answer here is not in an hour, probably not in a day, could we have canvassed everything that you need to know and be thinking about when it comes to this Act. That's the bad news. The good news is we are going to continue to be here as a resource to all of you, as will OKHR, and I think all this for one another. We will look for opportunities to push out advisories to anyone on our mailing list. We will look for opportunities to put together future webinars and updates, particularly after we get these regulations, which I'm sure everyone listening is thinking, when are those coming out? And I need to see them immediately. But we will do our best to summarize those and bring information to all of you. So this is just the first step in what is already felt like a long journey, but probably has a lot more chapters to tell. In closing, I just want to, again, give a tremendous thank you to OKHR. The conference is going to be as great as it's ever been when it comes around in August 10th through 13th. And the fact that they are not feeling sorry for themselves or just pulling themselves up by the bootstraps and creating opportunities like this for all of you, I think speaks volumes about the organization and about the commitment that we all have to one another. I said at the beginning, I'll say it in closing, we only get through this by working together. And we're proud to be a part of that here at Crowe Dunlevy, proud to be a partner to you in the business community. Please feel free to reach out to us. The lights are literally going out on me, which is probably the virtual equivalent of a hook to pull me off stage, but please reach out to us by email, by phone call, If you're not a client, then we are still giving out advice left and right and want to help people out. We want to be a part of the solution, and we thank you for this opportunity to be a part of it today. So we'll sign off and say thank you from Crowe Dunlevy and OKHR. Be healthy, stay safe, everyone. Thanks so much.